I feel proud and happy, not because I'm speaking of the three laws, but because it is dedicated to Ram Jethmalani. Ram Jethmalani was by far the best lawyer practicing on the criminal side. He was also a very good lawyer on the constitutional side, but on criminal side, there was nobody to match him. So, and I'm happy that Mahesh Jethmalani is carrying on these memorial lectures. I wish these go on for time immemorial. And now let me begin with the topic. As far as these three laws are concerned, you know that after about 5 decades, 7 decades, 10 decades, there is always a need felt to change the laws because so much has changed. The values have changed, the necessities have changed. So the laws which were in force earlier require to be overhauled. These three laws have precisely done the same to a large extent. It is possible that they have not covered every field. It is possible that they are not exhaustive. But they are a step in the right direction. They have taken into account the necessities of the time. Let me start with the first law, which I'm going to deal with, that is the Bharatiya Nagarik Suraksha Adhiniyam, earlier known as the CRPC. This law required an overhaul in certain aspects, not on all aspects, but the overhaul was particularly with the need to see that justice is delivered in time. You all know denial of justice, delay of justice is denial of justice. So that is how this new law tries to deal with the aspect of denial of justice because of delays. So they have tried to rectify as far as possible. I'm not saying that every loophole is plugged and every delay has been plugged. That's not the case here. But delays are sought to be curtailed and delays are sought to be reduced so that justice is delivered. Now, if you look at the provisions which are made in this act, which pertain to delays and which are sought to be rectified, the first is the provision where the director and deputy director of prosecution is entrusted with a task. That task is to ensure that there is speedy and expeditious disposal of cases. So one person, depending on the nature and gravity of the offense, is put on the top to see that all those offenses which require to be disposed of early are taken care of by an officer of a high rank. That is one way in which this act deals with the delay aspect. The second is that you know that sometimes what happens is you want an urgent order from the court. You want an immediate urgent order from the court, but the court is not available or the court expresses its inability to deal with the matter. What happens then? There is no alternative judge because it has to go before a particular judge. The judge is not available. In a city like a metropolitan, you have many judges, so it goes before another judge who's holding charge. But in districts, sometimes there's only one judge. What happens? So that contingency is also taken care of by incorporating Section 8, which says if a session judge is not available, the magistrate can pass an order in emergent situations. So that is one way of seeing that matters which require urgent attention are not delayed. Another important aspect that this law takes into account is delays on account of service of summons. You know, many times the accused deliberately delay the proceedings, or the police are inefficient, they're overloaded with work, they can't serve summonses. So service of summons, execution of summons, issue of summons, if it is done in the old way, say by postal way or by the police officer going to the house and executing the summons, it takes time. To obviate all that, the electronic mode is now recognized and accepted as a method of serving of summons and warrants. Of course, it can't be a non-bailable warrant. It has to be a bailable warrant, which can be done in this way. Then, examination of complainant and witnesses. It can be done in the electronic way. Now, this not only prevents delays, but it is also very helpful because the poor complainant, supposing he's staying in Bombay and he wants to required to deposit in Delhi, it causes inconvenience, it causes expenditure, it is time consuming. Therefore, to avoid all that, the new code says, examine them by video, examine them by video mode. Therefore, this is another way by which the time is shortened, the delays are curtailed. The third is the recording of evidence in inquiry and trials. That also is now provided that it can be done in the electronic mode. They have now also gone to the extent that appellate proceedings can also be held in an electronic mode. These are all methods devised to see that the delay, which is another facet of Article 21 of the Constitution. Speedy trial is one of the requirements of Article 21 of the Constitution, is tried to be matched with because of this. Then you would see that police reports. Earlier, police reports were always in writing on papers. That has been dispensed with, and a provision has been made that police reports can be even in electronic media. It can be in a pen drive. It can be even in a hard disk, in a CD given to the court. Even copies of the accused can be given in a soft copy. And now a new provision has been made that the courts, when they take cognizance, can take cognizance on an electronic charge sheet or a police report. So this shortens the time. This is another method by which the time is shortened. One more thing that with this act does is sanction. All of you have been practicing the criminal side, all the panelists, including Amit Desai, Aman Lekhi, and Aishwarya. You all know that sanction always used to take a lot of time. Sanction, whether it is under 19 of the PC Act, that is Prevention of Corruption Act, or 197 of the IPC, always used to take time. And many a times the charge sheets used to be filed without sanction, giving rise to a lot of litigation which say, no, it's an incomplete charge sheet, therefore give us default date. All that can be obviated because now the law is that you have, if you don't reject the sanction within 120 days, it is deemed to have been granted. So deeming fiction as far as sanction is concerned is another way of reducing the delays as far as trial is concerned. Now, as far as discharge applications are concerned, there was no time limit when the discharge, when the accused could file the discharge applications. If there are a large number of accused, one accused used to file after 30 days for receiving the paper, some would file even after a year. So now the law mandates that as far as the discharge application is concerned, it has to be filed within 60 days. So probably you'll lose your right to file a discharge application if you don't file it within 60 days. So if there are a large number of accused, one after the other filing of discharge application beyond 60 days is now avoided, can't be filed. Then you know that as far as judgments are concerned, many a times, many judges have faced the brunt of large number of people saying that you have reserved the judgment, you're not pronouncing the judgment. The new law says after completion of arguments in warrant tribal cases, you have to pronounce the judgment within 30 days. So that is another method or another way by which the speedy justice is delivered. In other matters, they have said 45 days from completion of the trial. That is another way of reducing the delays. Another thing that this new law says, you know that there's a provision where we file documents and ask the other side to admit the genuineness of these documents. Now people used to take time, they used to linger over it, especially the defense lawyers. And therefore now the new law says that you have to admit the genuineness of a document within 30 days. So 30 days is a time limit fixed by Section 330 of this new Sanhita or the Act. Then many a times evidence was of public servants officers, experts was being delayed because the expert who gave the opinion was either dead or not available. He was transferred, he had retired. So new law says a successor can come and depose. Therefore, you need not make out a case. You can just say he's not available, dead, retired, and therefore the successor can come and depose. Therefore, that also avoids a lot of delays. Then there is one thing which is something which I think they've borrowed from the NDPS Act. That is with respect to destruction of muddamal, as we call it, or material which is seized. There may be material like, say, in a case of prohibition in Gujarat where you seize liquor, it has to be destroyed. But that is required to be produced during a trial. Or say a car which is, or anything which is likely to deteriorate, or something which has, even is not likely to deteriorate, you're required to dispose it off by, and many times you make application either in the old section 451, etc. for possession. And when the person who has been given possession of this muddamal, say loses it or destroys it, something happens and is not able to come and not able to produce it. So now the new law says, it is akin to the NDPS Act, that the magistrate can prepare an sort of an inventory, take photographs, and that photograph will be admissible in evidence. So the accused can't complain that the actual material has been produced. I remember in a case where I was handling in Gujarat, the earthquake, the muddamal, the article which was seized and examined by the expert was huge columns of buildings. It's physically impossible to produce. And there were so many buildings which had collapsed, it was even difficult to identify which was the particular column. So that difficulty would be obviated, would cease to remain if this procedure is followed, which is there as far as the news CRPC or news Sanhita is concerned. Then, as far as not very small offences, but say not very grave offences like punishment with 3 years or more than 3 years and less than 7 years is concerned, they have now said that a preliminary inquiry is required to be held. In that way, for these type of offences, persons are not unnecessarily harassed because tendency to file false cases is always there, and a large number of cases which are false are filed. It is not necessary that all cases which are filed are genuine cases. So preliminary inquiry is required to be held, of course with the permission of officer above the rank of the DYSP or above the rank. But again, there they put a check saying that preliminary inquiry has to be completed within 14 days. So this would add a little as far as Lalita Kumar is concerned, that when a preliminary inquiry can be held. So 7 years, offences till 7 years, let the police be burdened with heavier offences, not these small offences where the punishment is 7 years. That is one more thing which has been added as far as the new code is concerned. Then as far as rape, examination of rape victim is concerned, there was always a delay in submission of the medical report by the medical practitioner. The new law mandates that within 7 days he has to submit the report. Now that is another thing which will also see to it that delays are reduced. Then timeline regarding supply of relevant documents to the victim and the accused. So victim is now been given a right as far as supply of documents are concerned, and apart from the accused who is otherwise entitled, that they say is 14 days from the date of appearance. Of course, now the delays are occurring because now all accused are asking for unrelied upon documents. That's different. But unrelied upon documents was never in contemplation at that particular time when this was framed. But even otherwise, I feel that as far as unrelied upon documents is concerned, whether the accused are entitled to it as a matter of right, whether they're entitled to inspection, it's all a matter of debate. There's one case which I've argued, the judgment is pending. So we'll see what happens there. So this is as far as the delay part is concerned and the speedy trial part is concerned. The case, the Sanhita, this is the Suraksha Sanhita, Nagrik Suraksha Sanhita is concerned, it also has provisions which help the accused. It has provisions which help the victim. It has provisions which help the complainant, informant, there's provisions which help the accused. Now, what are those provisions which help the accused? So it says, first provision that helps the accused is in a small offense which is punishable with less than 3 years imprisonment. And if the accused is infirm or is above 60 years of age, he can't be arrested without the permission of the officer, not below the rank of a DYSP. So DYSP is given more responsibility under this new act. Then it says, another thing which is very important. Many times it used to happen that the person is arrested, taken away from his house. Nobody knows who arrested, from which police station they have come. So now this law mandates that whenever a person is arrested, information is required to be given to a concerned officer in the district and also to the concerned police station, and is required to keep it in electronic form and give it to the person. So you can go to the local police station and ask, so they have arrested my brother, father, somewhere, where have they taken? So you can get these details. So that helps the accused and his relatives to find out about or the whereabouts about the offense, whereabouts of where he is, and about the offense in which he is arrested. Then there is one very important provision. The law is that at the stage of cognizance, the accused is not required to be heard. You're not yet required to be heard till the stage of plea. Now they have made a modification. They say before cognizance, the accused can be heard. This also contributes to, supposing there's a case where the accused can throw light, the complainant has to conceal certain material facts and got a summons issued against him. But the accused at that stage comes to the court and says, look at this document, it's concealed this. If you looked at this document, no process would have been issued. So that not only gives a right to the accused, but also reduces the work of the courts, high courts. You need not go and file a quashing petition and point out to the court saying that, look here, there's an impeccable document. Now, earlier view was you can't look at documents. The new view is you can look at impeccable, and documents of sterling quality can be looked at even at the stage of quashing. The accused can produce and have a look at it. The accused is concerned, you know, that old 436A, which provided that if he's undergone 50% of the imprisonment, not for life or death cases, is entitled to bail, which is even recognized by Vijay Madallal in the PMLA cases. So if you've undergone 50% of the imprisonment, you're entitled to bail because you have undergone 50% of the case of the imprisonment, which is meant for the case, but the case is not proceeding. Now that has been reduced in case of first-time offenders. First-time offenders, it is reduced to 1/3. So that is another. Therefore, if it is a first-time offender, the law treats him differently, and rightly so. He is not a habitual offender, first-time offender. So if he is there for 1/3 of the period of time, he is entitled to. And another thing which is important, he need not make an application himself. The jail superintendent is supposed to make an application saying that, look here, his imprisonment is 3 years. He's undergone one year. He's a first-time offender. He intimates it to the court, and the court will decide on the application or the information given by the jail superintendent. These are some of the features which help the accused. Now, as far as witnesses are concerned, Section 398 provides for a witness protection scheme. It's a very important thing. Of course, a little more work is required to be done, but the law now has provided that there can be a witness protection scheme like you have in the US, where the identity of an important witness can be changed. He can be given a new identity, placed at a place where if some gangster or some terrorist is after him, nobody knows where he is. So whether it is successful or not, whether there are loopholes, whether there are moles, that's a different thing. But the law has provided a contingency or a case where witnesses who apprehend that they will be killed, they will be threatened, their family will be threatened, are protected. In this way, what happens is that witnesses who are afraid will come forth, will be no longer afraid if the law protects them, and they would freely and voluntarily give evidence. Then there are certain new provisions which are there. One is handcuffing. How far that provision will hold the field, whether it is unconstitutional or not, will have to be tested because judgments on handcuffing, there are some judgments on the handcuffing, whether it violates those judgments is another issue. But it's not that in every case the accused is to be handcuffed and taken to the court. You know that there is a problem here. The courts say you can't handcuff. Many accused have taken advantage of this and escaped while they were being produced to the court. From the police van to the court, there are many instances. And I know of a few instances where the person just went to the bathroom from the window, he jumped and ran away. That's another. But even where the handcuffing is concerned, when you try to enter a lift or some place where there is a lot of rush, so therefore you have to strike a balance between handcuffing and escaping of prisoners. So their sort of balance is sought to be struck. Then another thing that this law does is the old 167, which is the new 187. Many a times the earlier law mandated, which has now been doubted in Senthil Balaji, whether the 15 days remand has to be the first 15 days or not. Or it can be anywhere between the first 60 days or 90 days as the case may be. But the new law rectifies this problem. And this required a rectification. You can't, supposing the police want an accused at a later stage where they get new material in the same case and they want the custodial interrogation, it's not permitted because of CBI versus Anupam Kulkarni. It says first 15 days. There's no logic accepting that the literal interpretation of the law. The law, if you really want to render justice, should be that when you require an accused, the police remand should be granted. Not because in the first 15 days, even if the requirement is after 16th day, you don't get a custody. That would result in injustice because you may sometimes require a custody of an accused after 15 days. So the new law says it is 60 days, the period of remand for the default bail, that is 7 years, etc. You get it for 40 days. Within 40 days, you can ask for that 15 days period will be anywhere between those 40 days. And in the other case, it will be anywhere between those 60 days. So this is a welcome provision. The lawyers for the accused may not agree. But in order to find out the culprit, get evidence, this provision was necessary. Then there is another provision which was there. That provision is regarding house arrest. Can a person be put under house arrest? Of course, constitutional courts have been doing it because there are no fetters on constitutional powers of the court. But as far as the magistrate is concerned, as far as session judge is concerned, can he say that I'm remanding you to judicial custody? Police custody, there's no question of home stay or home arrest. But judicial custody, can it be home arrest? In Navlakha's case, the Supreme Court granted home arrest. But that is because the Supreme Court is Supreme Court. It is not bound by the ordinary criminal law. But the issue still was whether a person can be put behind the bars in his own house, and that would amount to judicial custody. That has set at rest because they have now said that the only place where the person can be detained is a place where it has been declared to be a prison by the government. So unless the house is declared to be a prison, you can't be put under house arrest. That is another good feature, because otherwise rich and affluent people would say, give me house arrest. When to put a person in house arrest is another issue. Now, another important thing which is in consonance with the Supreme Court judgment is a voice sample. Earlier, there was a dispute whether an accused can be compelled to give his voice sample, whether it would be hit by Article 20, sub-Article 3, whether it would be self-incriminating. That has been put to rest by the Supreme Court, that even a voice sample can be taken, just like a blood sample or a fingerprint or a handwriting. That has now been incorporated in the CRPC. A magistrate can order the taking of voice sample, also apart from handwriting, fingerprints, etc. Another thing is, for this purpose, there is no need to arrest the accused. So that is something in favor of the accused. There's one more thing that the new Act does. It protects the public servants in the real sense. A Under the old laws, a public servant was protected only after it reaches the stage of cognizance. If a public servant has done something in the discharge of his duties, why should he face investigation? Why should he face arrest and wait for sanction till the cognizance? Of course, there is now 17A also in the PC Act, but that is only with respect to PC Act offences. So what does the new law say? The new law says that even for ordering investigation under the old 156(3), which is now 175(4), if it is against a public servant, you require a report from a superior officer. And if the public servant concerned is also required to be heard. So no cognizance without the public servant. Then no 156(3), no police investigation. Sorry. Now even at the stage of cognizance, which was old 200, now 223(2), they said same thing. They said, if you want to take cognizance against the police of a public servant, you can't do it without hearing him, without giving him an opportunity, and without asking and getting a report from his superior officer. So public servants are also now protected. In a way, they should be protected, not superficially, because till the cognizance is taken, we don't treat you as public servants who have done something in the discharge of duties, but only after cognizance you are treated separately, no trial. But what about arrest? What about other things? What about investigation? That is also taken care of now. Now, they've also applied the judgment of Siddharth. You know, earlier, 170 of the CRPC, where several magistrates were not taking the charge sheet unless the accused is brought in custody before them. Siddharth, that is 2021 Supreme Court online 615 has taken care of it. That thing which Justice Kaul had said in Siddharth's case has now been taken care of in section 190, which says you need not produce an accused along with a charge sheet. He is not to be taken into custody for producing the charge sheet. Then limitation also they've taken care of in this sense. See, if you look at the law of limitation, old 468, now 514, it says no court shall take cognizance. Now the issue was, is it supposing the offence has taken place, say, 3 years back, and the police after investigation files it, complaint after, say, although the FIR is registered on the day of the offence, the police files a charge sheet after, say, 5 years. And on the date of cognizance, it is time barred. So now they have taken a very practical view and said, no, it is not the date on which the cognizance is taken that the limitations will be computed. It is the date on which you file an FIR or date on which you file a complaint, and not the date of cognizance. That is also a very good thing that they have done, because the person was not inactive. He has moved the law enforcing agencies at the right time, in the nick of time, and he should not be penalized for any delays caused by the investigating agencies. Sometimes you go and file a complaint, the magistrate says fix for hearing, and the magistrate is transferred. It doesn't take place for years, and the file is lost. And after 3 years, it surfaces, and they say, no, now it is time barred because the date of cognizance is time barred. So that injustice has also been cured by this new law. Then victim and informant have been given also certain rights. The first right that the victim has been given is that he has to be informed within 90 days of the progress in investigation. Victim also is part of the justice delivery system. Justice has not only to be delivered to the accused, but it has also to be delivered to a victim. Victim must know, I have filed a case. What has happened to the case? Let me know about it. So a right to be informed about what happens to his case is also given by law, which is mandatory as far as the police is concerned. Sometimes what happens, prosecution is withdrawn without the victim knowing what happened, what is happening to my case. So now 321, which is the new 360, they say victim has to be informed and he has to be heard before prosecution is withdrawn. So victims' rights are also protected in a way. Now, one good thing about the last good thing, because I don't know.
Yes.
One, I don't know whether I have overshot my time.
No, yes.
But
please.
One last thing is this. This is a novel thing, that is community service as a mode of punishment. You have cases where the courts have given community service as a mode of punishment, but it was not a statutorily recognized mode. Constitutional courts have done it. The magistrate could not have done it. The moment the magistrate would have done it, a complainant represented by one of eminent lawyers as Amit Desai or anybody would say, there's no authority, how could you should have sent him to jail, why is he giving community service? Therefore, this is now statutorily recognized that in petty offences, not exactly petty offences, but borderline petty offences also, community service has been provided. In US and UK, they already had community service as a mode of punishment. So this is a good method of punishment, taking into consideration the modern requirements of law. Now, as far as the Bharatiya Nyaya Samhita is concerned, that the IPC, I just want to say a few things. Just give me a minute. So much that it's difficult to. One thing is that it recognizes gender, recognizes trans. So it is not only male or female, transgender is also recognized.
That's true.
Definition of child has changed. Then a new section is, there's always an issue. Many courts have held this way, other courts have held the way. Whether a promise to marry, if you have, say, physical relations with a girl, giving a promise that you will marry her and you don't fulfill the promise. Earlier, they used to file a case of cheating. Cheating, the court said, no, your intention at the inception was something else, therefore it may not amount to cheating. Now it has been specifically made an offence under Section 69.
Yes.
That is one thing. Then rape of a woman below 18 years, the life has been interpreted to be a remainder of the natural life.
Yes, sir.
Lynching, now these are all provisions which have been discussed when lynching has been made an affair. The negligent driving, if you run away from this vehicle.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.